So let me get this right, Josh. He was out on bond for the aggravated robbery. He was out on bond on the other case, on the retaliation, and then he picked up these two new cases, right? Is that right?
Let me check that.
I think he was out on bond for the ag rob, and then,
Oh, the
Picked up.
ag rob's from May.
yes. And then picked up
Picks up a
theft.
retaliation on 9/4, and then after that, so it's a third time he's out, and then he picks up another case?
These allegations, Judge, are from August of this year. There's two cases in this court.
Yes.
Let me see.
It was after the ag rob and before the retaliation.
All right, so the retaliation is September 3rd. Mischief is August 28th. Theft is August 8th, 28th as well. Officers get a call that a robbery has occurred. Complainant stated to officers two defendants later identified as Defendant Marshall and Defendant Ronald Waters, which was our other defendant from the other day, right? Remember Ronald Waters from yesterday? Hereinafter referred to as Waters and Marshall walked into a store, destroyed a glass partition, which was $300 to replace, and walked out of the store with 3 vapes and other stuff. Sodas and complainant stated both defendants walked in at the same time. Waters came up to the counter stating he wanted to purchase a t-shirt located behind the counter. While that was happening, Marshall attempted to come behind the counter, but the complainant was able to stop him. He reported that Marshall then came around to the front of the counter where Waters was. That he was distracted by Waters, who purchased a t-shirt, opened the packaged shirt, and seconds later wanted a refund, which he gave him the refund. Complainant reported that as that was happening, Marshall used his hands to mess with the glass partition, heard the glass breaking, grabbed 3 vape pens, other things, and ran out the store without any attempt to pay. Complainant states that he knows both defendants by sight and can identify them from priors. So while being out on all that, on the aggravated robbery, in that one, what do we have? Did he hold someone up?
The ag rob.
Yeah, let's see how dangerous Mr. Marshall really is. Allegedly.
So the complaining witness was a delivery man for Domino's. I believe he made a delivery to the co-defendant in that case. The complaining witness said he felt something wasn't right and told the co-defendant to just pay him half so he could leave. The co-defendant pulled out a handgun, pointed it at the complaining witness, and demanded the pizza. The complaining witness noticed this defendant by his vehicle at that point and observed Defendant Marshall open his front passenger door, reach in and steal a fanny pack that held his cell phone. So this defendant
Part of the offense. He's not the one with the actual.
he was not the one pointing the gun, yes, Judge.
The complainant began to feel that something was not right and offered to accept half the amount due for the pizza just so that he could leave the location. White then pulled out a firearm, pointed at the complainant, and demanded the pizza. White told complainant that he had 5 seconds to give him everything he had and began to count out loud. Do you know how scary that is to have someone hold a gun at you, tell them you have 5 seconds to give them everything or else? That is really, really terrifying and can cause people to have nightmares, all kinds of psychological issues. God. When defendant White reached his 5-second countdown, the complainant stated that he saw defendant White attempting to pull the trigger and could hear a clicking sound. It was at that moment the complainant was fearing for his life. He attempted to push defendant White's pistol away from his face and was able to retrieve his own firearm, namely a pistol. Complainant feared for his life and discharged the pistol at defendant White. Oh, the complainant shot and killed defendant White, who died at the scene. Complainant stated the defendant Marshall ran off with his property and the complainant drove to a safe location before calling the police. This is Houston. I will do everything in my power to protect our city. And I want you to understand that. And that person is now gone. For a pizza, his life is now gone. How well did you know this person? How well did you, was he a good friend of yours?
Someone I knew in the apartments.
I'm going to make each of your bonds $3,500, Mr. Marshall. I want you to understand that if you are able to make bond, I'm putting a whole host of conditions on you.
Sir, I will understand.
Don't be a danger to our city. You have but one life. Stop. You have but one life. You know, when it's gone forever. And it's so very, very short. So, heed the advice, because I'm not giving you any more warnings. Do you understand?
Yes, sir.
Okay. Thanks, Steve. Thank you. Good morning, Mr. Jones.
Good morning.
Mr. Jones, you were wanted out of the state of wherever. Probably denial, I don't know. But I have you here now because your lawyer is asking me to set you a bond.
Yes, sir.
I don't know. I've never met you before. I don't know who you
Order in
are.
the court.
No, my primary concern are two things. Number one, will you go back to the jurisdiction that you wanted from, number one?
Yes, sir.
More importantly, and most importantly, are you a danger to the community? I know that you're going to tell me that you're not. Everyone says that, right? But what really dictates is how you look on paper, because that tells me who you really are. So I just don't know. We'll go through all that and we'll determine whether, you know. I do know that you have an open evading arrest in a motor vehicle, so you're now charged with a third-degree felony.
Yes.
And so, all right, Amy, tell me about it.
Yeah, he's wanted from St. Lucie County in Florida.
Florida. Oh,
Yeah.
ouch.
He's wanted for a violation of probation for grand theft of a motor vehicle. We're asking for no bond at this time. For one thing, he picked up this evading of a motor vehicle while on that probation. He has,
Is this a stolen car too? Allegedly.
I don't think he was charged with that, Judge, so I would say,
Yeah, I mean,
a prohibited vehicle on the toll.
but we had an earlier case today, same thing, in a stolen car, right? Allegedly, and they didn't charge him with the UUMD, but they
Really?
could have.
okay.
So it's intake, I don't know, just these days it's,
I'm seeing prohibited vehicle on the toll. That's
so
all.
it is a prohibited vehicle?
On the toll.
So
I don't know,
a
but
prohibited vehicle could be a vehicle that
Yeah, it's
has
very,
outstanding
very
balance. That's exactly right. Or no tags or.
what other kind of criminal history he got?
Yeah, he has an obscene number of fraud and forgery charges out of Florida and Georgia.
How many?
22 pages worth.
22 pages worth of criminal history?
Yes, he also has
Whoa!
several failure to appears out of Florida. He was arrested in May 3rd of 2023 for a probation violation in Florida. Of course, this probation violation is for 3 different violations for failure to report and then changing address without permission, I think.
22 pages of priors.
Well, I would say this, Judge, sometimes the one case can take up to 2 pages sometimes, so
Even by that theory.
even, I get cheaper.
He also has misdemeanor and felony willful obstruction of law enforcement officers out of Georgia.
I'm surprised you even got probation. You know, I mean, really, it's you know,
All the charges were trickled down to 2 counts. So there was, all those charges are the exact same charge, and they dropped it to,
22 pages worth of the exact same charge.
it was 19 charges. and they brought it down to 2. They was basically 2 charges, 2 different kind of charges, but 9 charges of each. So,
It happened that would garner 19 charges. That's usually something where you have like a mass event, like a shooting, or like,
no, it wasn't like that.
The probation violation's original charge, which was a grand theft of a motor vehicle, he obtained that motor vehicle by,
like false
buying it.
pretenses or something.
Yeah, he tried to buy it with a false pay stub for a false company.
Judge, if I may.
Sure.
Judge, I'm not asking for a PR bond. I'm asking for, even if you consider a bond, a high bond amount that would allow him to go turn himself in. He would have skin in the game. It's a monetary sum that would ensure that he goes and turns himself in. He hasn't messed up in your court before.
I've seen.
I'm sorry. And so it would allow him to at least go present himself while also understanding the risk of losing a big deal of money. So I'd say that.
Whose money? Not his money. What kind of money you got? Doing what?
You know, I'd like to afford him the opportunity to post that bond. If you entertain.
Well, the first thing I'd need to know is, out of the 22 pages, what are all those, I'd like a list of like every single charge that he's ever had.
Okay.
I'd like to know the disposition of those charges.
Okay.
Because, you know, the problem is, Mr. Jones, is that when you have too much baggage, the more baggage you have, the higher of a flight risk you are, because you know that at some point you're going to have to answer to those charges, and you're going to try to.
But I answered to all those charges.
Well, I don't know that. I know you're telling me that.
I
But
understand, but those, I handled that. That was my first real case, and I handled it.
yeah, I mean,
And some of those with the FTA and stuff, I turned myself in. It was misunderstandings with court dates and stuff like that. It will show where I turned myself in like multiple times.
in this case here, you're trying to evade capture here. I mean, so I don't know. You know, I'd need to know a lot more about you before I were to grant you a bond, you know?
Like the current case, I can't speak on that right now. But
Don't, right, don't.
all the other cases, I turned myself in and I handled what I needed to handle.
You know, has he ever had a prior fugitive case before? Out of where? So Ricardo, if you want, we can do a deeper dive, or you guys can do a deeper dive and let me know more about him.
Here's the thing, Judge, I don't think it's, here's how this it would work. I don't have access to the 22 pages. I would love to give you the report by tomorrow. I can do that.
So
I
what
just
we can
don't
do
have
is
those.
we can ask Amy to print you out the NCIC report. Can you provide him with a copy?
I'd have to ask Dave. If that's all right with you, Judge.
They're, at least at the minimum, I know that they'll let you look at the report. So you can
Right.
look at it and write it down. I don't know if they'll give you a copy of it, but at least you can look at it, and we can try to work through to see all the charges of what they are,
Right.
try to find out what the disposition, but,
I can also go through it and.
right.
Okay.
But with 22 pages of prior criminal history, I'm gonna tell you now, it's a really uphill battle to get you a bond. And if I do give you a bond, it's gonna be a hell of a high amount now. In the high five digits, perhaps 6 digits, because no, I want to make sure that you turn yourself in. And the problem is that I know that there's a hurricane out there hitting Florida, so it's a perfect time for you to give me this kind of excuse there. I couldn't make it there. I couldn't make it here because of this and that. And when here,
Okay, I'll explain some of his options, Judge. We'll go over where we're at, and I'll see how he wants to proceed.
okay, but I'm going to tell you now, if I were to give you a bond, it's going to be in the high 5 digits.
Understood. Judge, my understanding is he already waived on October 8th, and so his pickup date is.
You know what? And I'm going to tell you now, we have at least 3 other people here from Florida. And I think it's Miami-Dade, right? Wasn't it Miami-Dade that we have?
I think
This
so,
one
yeah.
is St. Lucie County.
How far is that from Miami-Dade? So perhaps we can come get them to pick you up in addition to those 2, because I know that we have at least 2 transports that are coming here to pick up another 3 individuals from Florida. So maybe we can get you on that, and they're supposed to be here next week. You know, so if you waive, or luckily, I mean, you've already waived,
I've already waived.
so great. So
I'm not trying to run from nothing. I just want to get this over with.
here's the only other advice I'm going to give you now is that you need, if you do go back, you have to stay in contact with your felony lawyer in your felony case, because if you don't and they think that you've absconded, they're going to issue a warrant in that case, and then the hold that you have here for your Florida stuff, it's going to happen to you over here, because you're going to be over there, and then you're going to get a Harris County hold. So when you do finish up over there, you're not going to get out, and they're going to try to transport you back over here. That is Eileen Bogart is your lawyer over there. So just stay in touch with her to let her know what's going on, and that way they don't overlook it. Okay?
Thank you, Judge.
Of course.
That's all my time.
Thanks. Can you let Day know that perhaps we can get them on the train of transport? Good morning, Mr. Houlihan.
More.
How's jail?
Sucks.
Good. Wonderful.
Definitely don't ever want to come back here.
The worse of an experience you have, the higher likelihood you have of truly listening and realizing that we mean business, because that's what we do. When we when we tell you not to do something, it's not for shits and giggles, it's for the real deal, and you're not supposed to. And when you do, there are serious consequences. And coming in here and tell me it's NyQuil or this, I don't care. No alcohol means no alcohol from any source. Now, at the same time, I don't want you to plead guilty just to get out. Right? Because that's what you were going to do, and that's what everybody does just to get out, and I don't want that to happen. I'm going to give you another chance today. I'm going to put a monitor on your ankle so that I know that you're not consuming alcohol. And I'm going to tell you now, I will never play this game again with you.
Yes, sir.
So the next time you consume alcohol, and I don't care what source it is, and you've got your mom here to know, whatever it is, I don't care if it's the tequila lollipop, hair dye, you had dinner with Mother Teresa, whatever. The next time you consume, you will be with me. And you know now, you have no one to bond you out. So you're going to sit there for who knows how long. Do you understand?
Yes, sir.
No alcohol whatsoever.
Yes, sir.
The monitor that I'm going to put on you costs around $400 to $500 a month. I'm going to waive that fee for you so that there's no excuse. You need to charge that thing on a daily basis. So if the battery goes dead, so do you. You must charge it on a daily basis. Be careful for whatever you put in your body, because that machine is extremely finicky. It tests alcohol through your perspiration. So whatever you're eating, be careful. Apples, what happens to apples? What happens to bananas? They can become alcohol at some point. So you need to be careful. Apples, some fruit ferments. So just take that with what it is. Be careful whatever you put in your body.
Yes,
Are there
sir.
instructions somewhere that,
Yeah, they will advise him when he gets the monitor. They'll advise him on what he can and can't do, but it's also common sense. You have to know everything that you put in your body. If you're going to go to a party and there's a bucket of punch there, probably not a good idea to drink the punch, right?
Yes, sir.
Okay. Just use common sense.
Yes, sir.
It's not that hard, and be nice to people.
I definitely learned
I'm letting you out now.
I don't want to end up being like my father.
That right there gives you pause to concern. I mean, you're headed there. I mean, you're in jail. You're headed there. I mean, if there's no other wake-up call, then this is the wake-up call. Don't end up like that. You have the opportunity now to apply for a diversion program that if you get in, which you probably will if you do the application correctly, if you complete it successfully, they'll dismiss this case against you. It's a really big deal because when you get a DWI on your record, it closes so many doors. Not to mention your life, it's going to cost more in every respect. So just be good. All right. Yeah, drug testing as well. You're going to be tested 40 days from today. If you find weed in your system in 40 days, that tells me that you've continued to smoke weed. I'm going to put you in jail. Don't smoke weed. Don't go to any parties. Don't hang out with anyone that you think that they're going to use, because peer pressure sucks and it's very, very difficult. So if you're hanging out with the wrong people, they're going to take you down. No dope, no alcohol. You'll be tested in 40 days, and you know now what that machine does. Do you have any questions? Okay, listen to Mr. D, and then we'll see you in a couple weeks. Thanks for coming, Mo. Do you have any questions?
I'm gonna set up.
Remember, be patient with Mr. Dixon. He has so many cases. I mean, you see, he's running from court to court to court to court. He's like Speedy Gonzalez. So just take care, understand he has a lot of cases, and that if you call him, at some point he'll get to you. And
I'll meet with him in my office this Sunday.
and if you can always come here and meet here as well. We're always happy to have you at any time as well. Okay? All right, guys. All right. Good luck, Mr. Gallant.
All right, sir, this way for me.
Thank you, Your Honor.
Thank you, Mr. Dixon.
Judge, for clarification, 40 days more.
You have taken off on me 3 different times, Mr. Osborne. If you think that we are going to give you a PR bond, you are charged with assault, bodily injury. You're facing a year in jail. You had an offer in this case where they were going to dismiss this case, and you have repeatedly taken off, not once, not twice, but thrice. I am not going to give you a PR bond, and we are taking you into custody now. Your bond is now set at $10,003 because of all the times that you have taken off. And I get that you're in high school, but the problem is that you have already taken off 3 times. If I let you go now, what does that tell you? What? It tells you that it's okay for you to do what you're doing and not to hold you accountable. And that's not what we do here. You need to understand that courts are here for a reason. We do court orders for a reason. And when you fail to comply, when you fail to show, there are real world consequences. And I don't know if you have anyone that's going to bond you out. If not, you will be stuck like Chuck with me until this thing is over with. And I'm going to tell you now, I'm not into this pleading guilty, time served just to get out, just to ruin your life. I'm not going to let you do that.
We accepted the PTI. The state said they would still accept the PTI.
I get it, but I'm not letting him out.
Actually,
I mean, it's 3 times the case. How old is this case? It's a year old, and
you set your bond at 10,000, so you need to post 1,000 with the bond.
well, I don't know, because whatever they're going to charge you, I don't know. You're a flight risk. They may charge you more.
I asked a question.
Sure.
I don't recall leaving 3 times. I haven't.
You have a criminal case. You know that you are supposed to keep up with it. There's no out of sight, out of mind. You should have enough wherewithal to say, you know what? I haven't had court.
How you gonna do it to yourself yourself? This ain't the place where you ask questions, okay? All right.
You should have enough wherewithal to know, you know what? I have court and I haven't heard in a long time. What's going on? The only reason you are here now is because what happened?
Bonding company is attempting to get the case reinstated and or a new bond set for 'em. That's it. We wanted to let the court know it was our fault for not notifying him of
I'm
the
not
May
going to
setting.
all of the sword. It's not your
I
fault.
do understand. Yes.
You know, if it was one time, okay, but we have 3 different times. It's unacceptable. Okay,
If I may,
sure.
he did miss court 3 times, but he missed the first one because I couldn't reach him because the phone number I had was disconnected. I reset it 2 more times to try to get in contact with him. So he didn't purposely miss 3 court dates just because I couldn't. The phone number I had for him.
He
wasn't
knows he has court, Mr. Schofield.
I understand.
You know,
I'm just-
behavior has consequences, and now you're going to see that there are serious consequences to it. He goes with you. I'm not out for blood, but I want him to understand that we mean business. If he is unable to make a bond by tomorrow, then we can talk, and I'm happy to entertain perhaps something tomorrow. I get it that he's in high school, but I want him to understand that we mean business. And if I just let him go now, it's enabling him, and it's not a good thing. But I'm happy perhaps tomorrow, if he's unable to make bond, We can talk about a PR bond tomorrow.
Should we just set it for review for
He's
tomorrow?
gonna come back tomorrow regardless because they'll auto-populate.
Okay.
Because that's what happens when we take someone into custody, they auto-populate for the next day. So we can talk about it tomorrow about, because I'm not gonna let him plead guilty just to get out and just to get a conviction on his record. And I'm happy to do this, but I want him to understand that we mean business and we're not playing games. So if he's still here tomorrow, we can talk about doing a PR bond and we'll let him try that. But I'm gonna tell you now, he gets an ankle monitor, curfew, and I'm gonna drug test him. And I'm gonna be his dad. That's it. Okay. All right, thank you. Mr. Johnson, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officers were dispatched in Harris County, Texas. The complaining witness was downtown in Houston to celebrate her birthday that late evening and had consumed a moderate amount of alcohol while out. The complaining witness stumbled and caused an item in the bathroom to fall. The defendant entered into the bathroom and became aggressive because he thought she had been throwing things around on purpose. The defendant grabbed her using both of his open palms and grabbed the base of her neck and began squeezing it to the point she was unable to breathe and caused her pain. The complainant stated that the defendant, then released his left hand from her neck and then used his right hand to press her head against the edge of the bathtub. The CW stated that
So the bathtub, you say?
on the edge of the bathtub, yes, Judge, that's what it says. The complainant stated that the defendant then struck her multiple times in the face with his left hand and caused her upper and lower lips to become swollen, bruised, cut open on the inside of both upper and lower lips and caused additional pain. The complainant stated that the defendant also struck her in the right eye with either an open or a closed fist, which caused her even more bruising, swelling, and redness to appear.
What's the relationship?
It doesn't appear that there was one, Judge.
The complaining witness and the defendant were in a dating relationship at the time. They're no longer in that dating relationship. I just spoke to her yesterday.
Were they in a dating relationship at the time?
Yes, Judge, at the time of the offense. And then he went to
It's
school yesterday.
the wrong charge, Judge, again. I don't know what to say.
Mr. Johnson, it's very possible that they indict this as a felony. I would be very, very careful because it could be very well is an impeding choking case where you'll be facing 2 to 10 in the penitentiary. As it stands, I'm sending you for a drug test right now. I want to know what, if anything, is in your system and you're to come right back. If you fail to take the drug test, if you fail to come back, I'm going to revoke your bond and I'm going to make it high. Do you understand? No more PR bonds for any new charges, anything you pick up, any violation of conditions that you may do. You're not going to get any more PR bonds. Do you understand? And I'm going to tell you now, I'm going to do everything in my power to protect my city at all costs. So I'm going to have you sign a reset and we're going to send you for a drug test and we'll see you back in 30 minutes. That way.
Page 18, Mayfield.
Yeah. I'm going to test you 40 days from today. If you test positive for marijuana again, I'm going to revoke your bond and put you in jail. If you test positive for alcohol again, because I'm going to randomly test you, likewise, you will go to jail. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm ordering you to work full-time or get into school full-time as well. No contact with the complaining witness in this case. Do you understand? And I'm telling you now, it's very possible that they indict this as a third-degree felony. And if you have any prior pen trips, you could be looking at a serious 15 to 25 to life case. But like I told you before, I'm going to do everything in my power to protect the public at all costs. Do you understand? THA? And then he comes back and we test him in 40 days. Do you have a Texas driver license?
It's expired, but
And you are not allowed to drive. And I'm making it a condition of your bond that you're not to drive. And you will be signing an affidavit with me. You just had a tampering with a government record dismissed 3 months ago. So I'm ordering you not to drive as well, unless you have a valid Texas driver license and liability insurance. And I'm gonna have you sign an affidavit with me today promising me that you're not gonna drive, Mr. Johnson. Sorry?
I got a question. I got a question.
Shoot.
Why you telling me like this case has nothing to do with drugs or like driving? I didn't get in trouble for no drugs. I have never got chosen drugs or drinking or anything in that matter. I never in life got in trouble for it.
I don't want you using while you're on bond for this case, and I don't want you using and being in a state that could potentially lead to other charges because you're in a state that you shouldn't be. So if you have problems with drugs or alcohol, you better address it, Mr. Johnson, because if you don't, I'm gonna do it for you.
I'm not saying I have a problem. I'm just trying to see like this case happened. I think they said in what?
When was the charge?
Yes, ma'am.
I get it, but Mr.
April 17th.
You know, listen,
Like,
hold on, Mr. Johnson.
Since like with no alcohol or no marijuana or nothing.
Resisting arrest, assault of a family member, possession of a dangerous drug, possession of marijuana, unlawful restraint, theft, possession of a controlled substance, out-of-state fugitive case, harassment, out-of-state fugitive case where you had a desertion from LA County where we gave you a $60,000 bond, tampering with the government record, and now another. I'm not going to argue with you. I want to do everything on my power to keep the county safe. And if you're clean, I'm not going to. This is what's going to happen. I don't want you using alcohol. I don't want you using any illegal drugs. I don't want you to have contact with her. If you don't have a Texas driver license, don't drive. If you don't have liability insurance with your name, don't drive. I'm asking you on every single one of those things. I'm asking you to follow the law. I'm asking you to be a nice and good person out there. That's all I'm asking.
Do not talk to the prosecutor.
I didn't know she was the prosecutor.
Don't talk to the prosecutor.
Thank you.
You need to talk to the You get to say THA, you're on the right? Yep. You need to hire an attorney, that's what the judge is saying.
I can't, I don't work, so how can I?
One of your bond conditions is that you get a full-time job, mister. This isn't up for negotiation. These are your bond conditions. I want you to become a productive member of society. That's it. So I'm going to have you now sign this affidavit promising us you're not going to drive. I will get you to Victoria, sign a reset. After that, I'll get you with pre-trial for your bond conditions, and then we'll see you in 30 days.
But I just want one more question. So when I come back to court, is this just for the drug test or just like the overall?
Just make sure that you're in compliance for you to have a lawyer. And then in 40 days, I'm going to drug test you again. So don't smoke any more weed after today. Okay.